We only have one item on the agenda this morning in reference to the retention letter from Rotzel and Andrus, legal representation of Geauga County Judge Timothy Grendell and Geauga County Common Pleas Court Probate Juvenile Division. Dave, do you want to kind of just give a quick history?
I can,
Yeah.
we've been through so much in the last week.
I think I'm comfortable saying I know how this flows. We should have a flow chart here.
We should have.
Can you explain it to me? Because of all
Yeah.
the things that we've dealt with, this is probably one of the most complicated.
I was up to about 1 a.m. last night sitting there, making sure I was reading all this correctly.
Yeah.
And
So-
I read that same thing.
Yeah, I mean, this all started, I believe, when the juvenile probate court wanted to get outside counsel on a couple of juvenile cases.
Yes.
And Prosecutor Flaiz had a problem with that, so he came to the commissioners and applied for counsel to pursue, defense of that action.
Mm-hmm.
So then, a while later, the juvenile probate court came and submitted a request and a letter from Rotzel, which was his attorney he wanted to select, and it was a retention agreement.
Mm-hmm.
And the retention agreement, stated, that he wanted to started working in defense of the juvenile probate judge.
Mm-hmm.
And so this office, initially reading it, had two issues. One, we had been informed that there was no pending or no action actually having been taken by the prosecutor against the judge.
Right.
So then the question might be, does the judge need representation right now? So that was question number one.
Right.
Question number two was the hourly rate. In the original engagement letter, Mr. Stephen Funk, the attorney for Rotzel, mentioned that his typical billing rate was $395 an hour. He was willing to mark that down to $365 an hour with a lower rate for an associate. So we consulted, this office consulted with the counsel that we had secured to help us with outside issues where there was a conflict.
Right. Because we had to go outside counsel.
Right,
Because
so
our
we're using
prosecutor-
Walter Haverfield, and the lead attorney's name was Todd Hunt. And he looked at it initially based on what we knew, and he said, yes, I don't see why it's necessary for the judge to have counsel right now, because it doesn't appear that the prosecutors filed anything against the judge.
Mm-hmm.
And the law states clearly that the commissioner's office, their involvement in this process, well, first of all, it's supposed to be when outside counsel is requested, there's supposed to be a joint application that involves the commissioners. And part of the reason that's supposed to be the case is the commissioners, as the funding authority for the county, are supposed to have some say in how much is being paid for outside sources.
And we have to make sure that we have the budget
Make sure we have the
necessary
budget.
and so on, so we can't spend money we don't have.
So several weeks ago on a financial, we had some discussion. We approved encumbrances to get money set up in a purchase order for these outside attorneys. The judge had actually engaged another attorney to work on the issue in the Supreme Court that had been filed by Prosecutor Flaiz,
Right.
and also Rotzel and Andrus. So we didn't agree to paying any specific rate. We just simply said, we're going to put money in place that if something's agreed to, we're covered for any invoices that start coming.
Right. Right.
Okay. So ultimately, the board decided last Tuesday, it's only a couple days ago, to send a letter back to Mr. Funk and Rotzel and kind of answer him back to say we are very respectful of the process, of the right of the judge to seek counsel if he needs it. We just would comment that we don't think there's an imminent need for counsel, and we have some concern about the rate because the going rate for attorneys providing services to local subdivisions ranges down to as low as $175 an hour, was quoted for an attorney that actually had been secured by the prosecutor.
Mm-hmm.
So I got a call the next day from Mr. Funk, and we ended up having a very nice conversation, and he explained issues that were involved. One of the issues that were involved is that because the prosecutor had filed with the Court of Appeals challenging Judge Bird's order of appointment of outside counsel for the juvenile cases, that their contention was, well, then that's something that does impact the judge. So under law, as far as the guidelines for appointing counsel, the argument there is, No, even though it's not right against the judge, it's against an order that was put in by Judge Burt that is in the interest of the judge. Therefore, Mr. Funk was advocating that, in fact, his client did need representation. And as to the rate, he came back and said, well, I had originally quoted $365, but I will extend to Geauga County the same rate that we charge the city of Cleveland, so that rate will now be $275 an hour, $90 an hour less, and for the associate, it'll be $225 an hour. So he then followed that up with the letter that's before you today, retention letter for you today to consider signing.
And I think one other thing that was in midstream in this process was also that the juvenile probate judge had filed a clarification of the order appointing counsel.
Yes.
Basically seeking a court order or a contempt order
Yes,
against
and
the commissioners.
he sent that, he filed that late Tuesday afternoon after you guys signed the letter in response back to Rotzel. We were never copied on that. We were just made aware that he had done that.
That's right.
So based on that, then we crafted a letter that I signed after consulting with each of you at separate times and consulting outside counsel back to Judge Burton, just saying, this is where we're at, this is what we've done.
Right.
Because there were some things in the order that we're reflecting perhaps the juvenile court and this office weren't on the same page with understanding certain things.
Right. I mean, in no way were the county commissioners, as listed in this this clarification order, seeking to deny counsel or anything like that.
Yes.
But the commissioners do have a right by law to negotiate the price, and that was all that we were saying is that we're a part of this process.
Right.
And then Judge Burt found that there was no contempt also, right? Correct?
Yeah, well, he didn't even bring it up. And
Right.
and if I can just quote part of his order that he issued yesterday afternoon in response to Judge Grendell's filing, said, the onset, it must be known the 11th District Court of Appeals has previously stated, quote, the sole role of a court of common pleas in the appointment process is to authorize the Board of County Commissioners to employ special counsel. Once such authorization has been granted, it is a duty of the Board of County Commissioners to provide for the compensation of that counsel. Given the specific language in RC 305.17, RC 305.14A simply cannot be interpreted to grant a court of common pleas any authority to set the amount of compensation for special counsel.
Right.
And he cites the Simmons versus Geauga County case back from 1997.
And then he does say also the court does not have the authority to set the amount of compensation for Mr. Funk or his firm.
Right.
Since the Board of County Commissioners and Attorney Funk appear to recognize that the board has the authority to determine the compensation of appointed counsel and the rate of compensation has been negotiated, the issue of the rate compensation may well be moot.
Yeah. So it's, to kind of summarize, it's the duty of this office to look out for the taxpayers. And, the court has the authority to order that counsel be provided for an elected official who needs it. But this office's job is to look out for the taxpayers and to negotiate a rate that, is looking out for those interests, but while at the same time ensuring that the elected official or judge gets the representation they're entitled to.
Right, and I think it's significant because Judge Burt recognized the statutory role of our office.
That's right.
Yes.
Which
That's
is
right.
not only to help negotiate the rate, because we're the budgetary authority or the financial authority, but also to be involved in the process. And for some reason, people want to kind of avoid our
Separation
office.
of powers.
And so,
Yes.
but us, even to the point where we can help select an attorney. Now, in this case, we're not going there. But we have a right to be involved in that process, to talk about what attorney we're going to use, what rate is going to be involved, and Judge Burt commented on that, and thank you to him for doing that. Now, all that said, we can't, this is my personal perspective on this, it's not our role to intervene. We're not attorneys.
Right.
We can't determine the merit of one side or another. We can't say whether the prosecutor is right. We can't say whether the judge is right. We don't have the legal training, the legal background, or the place to do that. And so it's really, as much as I hate it, because this is costing the taxpayers
That's right.
a ton of money, we don't have a right to intervene in that process. Our only role in this process is to ensure it's done as cost effectively as we can, and that it's reasonable and necessary, and that's the extent of what we can do. As I read the law and as I understand it, with my limited background, I didn't stay at a Holiday Inn last night, but
We've all had to learn a lot more about the law
But, I
than any
mean,
of us
that's
ever
right.
wanted.